Hello, fellow We the People. I got court coming up here in a few days, and last time I was in court, the judge told me that I really needed to study the law seriously or get an attorney. So this time when I go into court, I'm going to ask the judge if as soon as he calls me, I'm running right up there with my books and stuff, and I'm going to tell him I've been studying diligently, Your Honor, and I'm going to ask him if he has an oath of office, if he's turned one in, and he's going to say he did, and I'm going to ask him if he'll please recite it for me. It's a simple oath. I'm sure you can remember it. And as soon as he recites it, then I'm going to tell him I accept his oath of office as a legal binding oath. And I'm going to start this brief, and it goes like this. The Constitution of the United States, Article 1, Paragraph 2. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Washington State Constitution, Preamble. We, the people of the state of Washington, grateful to the supreme ruler of the universe for our liberties, do ordain this Constitution. Article 1, Declaration of Rights. Section 1, Political Power. All political power is inherent in the people, and the governments derive their just powers from the consent of the governed, and are established to protect and maintain individual rights. Section 2, Supreme Law of the Land. The Constitution of the United States is the supreme law of the land. Section 3, Personal Rights. No person shall be deprived of life, liberty, or property without due process of law. Article 4, the Judiciary. Section 28, Oaths of Judges. Every judge of the Supreme Court and every judge of the Superior Court shall before entering upon the duties of his office take and subscribe an oath that he will support the Constitution of the United States and the state of Washington, and will faithfully and impartially discharge the duties of judge to the best of his abilities, which oath shall be filed in the office of the Secretary of State. Blackstone Commentaries, Cooley's Second Edition, Volume 1, Book 1, Chapter 1 of the Absolute Right of Individuals, page 122, paragraph 6. By the absolute right of individuals, we mean those which are so in their primary state and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy whether out of society or in it. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them, for the end and intent of such laws being only to regulate the behavior of mankind as they are members of society and stand in various relations to each other. They have consequently no concern with any other but social or relative duties. Let a man therefore be ever so abandoned in his principles or vicious in his practice, provided he keeps his wickedness to himself and does not offend against public decency. He is out of the reach of human laws. The freedom to travel is a fundamental right and should be unlimited by statutes, rules, or regulations which unreasonably burden or restrict this movement. A law which substantially affects or penalizes the exercise of the right to travel may be justified by a compelling state interest and must be tailored carefully to avoid unnecessary infringement on the right. Chaparral v. Thompson, 394 U.S., page 618. The purpose of inhibiting migration by needy persons into a state is constitutionally impermissible. All citizens must be free to travel throughout the United States uninhibited by statutes and regulations which unreasonably burden or restrict this movement. If a law has no other purpose than to chill assertions of constitutional rights by penalizing those who choose to exercise them, it is patently unconstitutional. The Equal Protection Clause prohibits a portion of state services according to park tax contributions of its citizens. Any classification which serves to government interest is unconstitutional. The right to travel is clearly established. Looking into the case, we find that the right has no explicit mention in the Constitution. The right was so elementary it was conceived from the beginning to be a necessary concomitant of the stronger union the Constitution created. The freedom to travel throughout the United States has long been recognized as a basic fundamental right under the Constitution. The right has been clearly established. The right is clearly there. And moving from jurisdiction to jurisdiction, they are exercising their constitutional rights, and any classification that penalizes the exercise of that right unless shown necessary to promote a compelling government interest is unconstitutional. The reality is they were exercising their constitutional right to a timely travel, and the state did not want to allow it. Number 1, the Constitution of the United States is the supreme law of the land. Marbury versus Madison, 5 U.S. 137, 1803. The Constitution of these United States is the supreme law of the land. Any law that is repugnant to the Constitution is null and void of law. Number 2, the right to travel is clearly established. Chaparral versus Thompson, 394 U.S., page 618. All citizens must be free to travel throughout the length and breadth of our land uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. Thompson versus Smith, 154 S.C. 579. The right of a citizen to travel upon public highways and to transport his property thereon either by carriage or by automobile is not a mere privilege which a city may prohibit or permit at will, but a common law right which he has under the right to life, liberty, and the pursuit of happiness. Number 3, no state shall convert a liberty into a privilege. Murdoch versus Pennsylvania, 319 U.S. No state shall convert a liberty into a privilege. License and attach a fee to it. Number 4, if a state converts a liberty into a privilege. Shuttlesworth versus Birmingham, 373 U.S. 262. If a state converts a liberty into a privilege, the citizen can engage in the right with impunity. Union Pacific Railroad versus Botsford, 141 U.S. 250, 251, 1891. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others unless by clear and unquestionable authority of law. Miranda versus Arizona, 384 U.S. 436. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Norton versus Shelby County, 118 U.S. 425. An unconstitutional act is not law. It confers no right. It imposes no duty. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Miller versus U.S. 230 F. 486, 489. The claim and exercise of a constitutional right cannot be converted into a crime. Number 5, liability. Brady versus U.S. 397 U.S. 742, 748. Waiver of constitutional rights must not only they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Boyd versus U.S. 116 U.S. 616. The court is to protect against any encroachment of constitutionally secured liberty. Cooper versus Aaron, 358 U.S. 1, 78 SCT 1401. 1958. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Owen versus Independence, 100 SCT 1398 445 U.S. 622. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know the law. Number 6, summary. I was not driving. I was standing in line in the store, waiting in good faith for my turn to purchase a chose. Had I been traveling, I would have been so within my constitutional right, and that right is supreme to any law legislature can pass. Legislature cannot pass any law that restrict or take away rights. If they do, it is unconstitutional. Murdoch versus Pennsylvania. No state may convert a secured liberty into a privilege. If they do, Shuttlesworth versus Birmingham says one may ignore the license and fee and engage in the right with impunity. Had I been traveling, I would have been within my constitutional right, relying in good faith on prior Supreme Court decisions to do so. There is even a perfect defense to the charge of willfully. U.S. versus Bishop, 412 U.S. 346 defines willfully as evil motive or intent to avoid a known duty or task under law with a moral certainty. Since I was standing inside the store, I could not have been driving. Even had I been traveling, I would have been so within my constitutional right too. Relying in good faith on previous Supreme Court decisions, there is no evil motive or intent so I still would have a perfect alibi. May it please the court, I motion for dismissal with prejudice for failure to state a cause of action in which relief can be granted. Okay, I'll let you guys all know how that goes. That's a pretty good mouthful. Thanks.